Yeah, the Constitution was passed purely as a negotiated separation of power between state and federal governments, and it totally abandoned any concept of an American Bill of Rights and was about power sharing in the Federation. Surprisingly, over 110 years, some very fundamental protections have been found to exist in the Constitution, which weren't really thought of very much at the time, but which are part of the Constitution's adaptation to a modern society. So as society changes, there are economic, social, cultural changes. The Australia you see in 2012 bears no relationship whatsoever to the Australia you saw in 1901. Yet that document has remarkably and surprisingly adapted to that changed environment. And part of that change has been the protection of human rights that have arisen from the Constitution in a number of areas, so that now you find the courts stand as a real bulwark for protecting human rights, protecting the rights of the underclasses, the people who don't have a voice. Suddenly you find they're appearing in the High Court, they're appearing in the courts. I mean, it's no accident that a lot of the most important decisions have involved refugees or involved Aboriginal people or involved people, prisoners, so groups that really had almost no legal voice, or in fact no legal voice at the time of Federation, have found to have very fundamental protections in the Constitution given to them, which have been developed over the last, particularly the last 20, 30 years. Yeah, that's a complicated question. When you say the Constitution protects human rights, it's protected certain areas of human rights, so that it's protected human rights against arbitrary and capricious executive government power. The courts control all power and make sure it's exercised lawfully and in accordance with law. And the endeavours by government to limit judicial review have basically failed. So that means the separation of powers doctrine and the principle of legality has been used in a way that's highly protective of legal rights. There's also the representative democracy cases which show that the constitutional protection for our democratic system is now firmly embedded, and government can't really fiddle the electoral rolls or the electoral system to, in effect, ensure that we have something less than a true democratic election. And that gives freedom of speech, it gives the right to vote, it gives a number of aspects which weren't, freedom of political speech that is, a number of aspects that were not really thought of as being within the constitutional realm. There are other aspects where human rights become important, so it's limited. A Bill of Rights is much wider, but we as a society don't seem to be prepared to go down that route. And it's not as bad a thing as I would have thought, because what it's forcing people to do, governments to do, is to look at problems which are complex and maybe not solvable by a Bill of Rights, such as equality and so forth, and actually deal with them in a structured way. So we've got the discrimination legislation, race discrimination, sex discrimination, disability discrimination. Those acts are far more beneficial and far more protective of human rights than any Bill of Rights could ever be. They've got their problems, but a Bill of Rights could never achieve what they achieve, so that the difficult areas that need specific legislative prescription are often better solved by attacking the problem in a very measured and structured way, rather than trying to rely on a High Court interpretation to give some general principle that really won't be sustainable over time. So that's why it's important. The best example is in Victoria recently we had the abortion, surrogacy, IVF access legislation. Now, no Bill of Rights could have ever achieved what that Act does achieve. Now, some people say it went too far, others say it didn't go far enough. It doesn't matter. On the fringes, that's not a problem, but it's actually solved intractable problems and given human rights in areas that a Bill of Rights probably could never have been used for. I think Australia is an inherently conservative society, conservative to a degree, and that degree is that if something's not seen to be a problem, you don't change it. And the Constitution, when it seemed to be a problem, has been changed, so that in 1967 it was seen that there was a great failing in not having Aboriginal people being able to be subject to federal law, leaving their future to the anomalies of what state parliaments and territory parliaments may decide to do. So it was important that that change be brought about, and it was something that people recognised had resulted in grave injustice in the past, so it was to be corrected. Ironically, it's been interpreted as allowing detrimental laws, not just beneficial laws, to be made, giving rise to the current concern about change. But Australians basically say, it's worked, if you don't have a problem, don't ask me to fix it. And so generally the changes have been obvious, like judges were required to retire at 70 rather than life, but that all came about because a High Court judge was sort of nodding off and it was a bit of an embarrassment. So 70 was fixed some considerable time ago as the age for retirement. Now that's probably younger than maybe current ageing would suggest, but generally speaking, those sorts of referenda will get past the public because they're bipartisan. But I don't think there'll ever be a referendum that's passed which is opposed by one of the major parties.